You are a disgrace to this court. I have nothing but contempt for you and your—
There are moments in a courtroom that stop everything. Not because of shouting or drama, but because of one sentence that lands so quietly, it takes a few seconds for people to realise what just happened. This is one of those moments, and there's a detail in this case, something in the officer's report that most people overlook entirely. By the end, you'll understand why that detail matters more than anything else. I am Frederick, and I cover real courtroom moments worth talking about. Pull up a chair. This one earned its place. If this sounds like the kind of story you'd want a friend to tell you, hit that like button before we go any further. The case started simply enough. A 19-year-old named Madison Hartley walked into Providence Municipal Court on a Tuesday morning for what should have been a 10-minute hearing. She had a speeding ticket. She had an attorney. She had the particular composure of someone who had never truly lost anything, who moved through life expecting rooms to adjust for her rather than the other way around. Designer clothes, phone in hand, sunglasses sitting on her head despite being indoors. The kind of entrance that told people in the gallery everything before she even opened her mouth. But here is the thing about Madison Hartley that the citation alone didn't capture. She hadn't arrived at that courtroom door through a series of bad decisions made in a single, reckless afternoon. She had arrived there through years of accumulated insulation from consequence. Layers of protection built up so carefully around her that she had genuinely stopped recognising where her choices ended and other people's safety began. That's not an excuse. It's a context. And context matters in courtrooms because it tells you whether you're looking at a person making a mistake or a pattern finally catching up to someone. Madison had grown up in the governor's mansion, private schools where her last name opened every door before she had to knock. Luxury cars handed over on birthdays like they were unremarkable gifts. Credit cards with limits that most families would consider a full year's income. She had been told no before, of course. Everyone gets told no at some point in life, but the difference was that for Madison, no never truly stuck. High school infractions had a way of vanishing before they reached any official record. College continued that same pattern of quiet erasure. Every sharp edge that might have taught her something got filed smooth before she ever had to feel it pressing against her. The result, after 19 years, was someone who had never actually metabolized a consequence. She had heard the word. She had never experienced the weight of it. By the time she was 19, she had accumulated 5 traffic violations in 2 years. Not one of them had produced anything that looked like a real reckoning. Judge Frank Caprio was already at the bench when her case was called. He had been handling cases since early morning, patient and measured as always, the way judges get when they've spent decades understanding that the people standing before them are rarely as simple as the charge sheets suggest. He had presided over cases involving grief and stubbornness, genuine hardship and manufactured excuses. People who deserved breaks they hadn't asked for and people who expected breaks they hadn't earned. He had learned to read not just the documents in front of him, but the posture of the person standing at the defendant's table, the way a jaw was set, the way eyes moved or didn't move when something uncomfortable was said. He opened the folder in front of him and read carefully. What he found wasn't simple at all. The citation said Madison had been driving 55 miles per hour through a school zone posted at 25, not a residential block, an elementary school zone, during afternoon dismissal, when children were leaving through every exit, when parents were lined up in careful rows, when crossing guards had their signs raised. The report also noted she had run a stop sign without slowing and that her head had been tilted down toward her phone the entire approach. That combination, the speed, the phone, the school zone, the stop sign, wasn't a lapse in judgment that happened in a fraction of a second. It was sustained inattention. It was the kind of driving that requires a person to be somewhere else in their mind entirely, to have made an ongoing decision, even if unconsciously, that whatever was on that screen mattered more than whatever was beyond the windshield. But the part of the report that carried real weight was a separate note filed by the responding officer. His name was Thomas Reynolds, 15 years on the force. He had been at Oakmont Elementary that afternoon, not for traffic enforcement, but to give a safety presentation to third graders. His own daughter was in that classroom, sitting in the second row, proud that her father was teaching her class how to cross streets safely. She had raised her hand for every single question. Reynolds had seen her from the front of the room and had felt the specific kind of contentment that parents feel in moments they know they'll remember. He stayed after the presentation to help manage dismissal traffic. That's when he saw Madison's car. Even from a distance, something registered wrong. The speed didn't belong on that street. He watched the car cover the gap in seconds that should have taken much longer. He saw her head down. He saw the stop sign she was approaching. He saw children already stepping into the crosswalk with the honest confidence of kids who've been taught that crosswalks are safe. One of those children was a 7-year-old named David Chen. He had a backpack almost as wide as his shoulders, and he walked into the crosswalk with the careful focus of a child who remembered every rule his parents had taught him. Look both ways, wait for the signal, trust the crossing guard, make eye contact with the driver before you step out. He did all of it correctly. Every single thing his parents had drilled into him since he was old enough to understand streets and cars and the importance of paying attention. He did all of it right that afternoon. And it almost wasn't enough. Halfway across, he saw the car. It wasn't slowing. His small body simply locked up. He couldn't move. His brain couldn't reconcile what his eyes were showing him with what every trusted adult had told him about crosswalks being safe. 7-year-old minds aren't built to process that kind of contradiction in real time. So he froze. Backpack on his shoulders, feet planted on the white painted lines, watching thousands of pounds of metal approach him without any sign of stopping. The car swerved at the last possible moment, missed David by roughly 18 inches, close enough that the displaced air moved his backpack. Reynolds pulled Madison over 2 blocks later. His hands were shaking, the report said. Not from anger, from the fear that comes when a parent realizes how close something terrible just got. From the specific horror of knowing that his daughter had been sitting safely in a classroom while another child nearly didn't make it across the street outside the same building. He approached the vehicle with the professional composure that 15 years of training had built into him, the composure that holds even when everything underneath it is moving. Madison rolled down her window, already irritated. She told him she was in a hurry, that she was meeting friends, that she didn't appreciate being stopped. When Reynolds explained what had happened, the speed, the stop sign, the child who had frozen in the crosswalk, her response was that nothing had actually happened, that this was being blown out of proportion. She looked genuinely confused by his concern, the way people look confused when the rules they've always operated under suddenly don't seem to apply. And then she said the phrase that made Reynolds decide this case would not be quietly processed and filed away. Just call my father's office. They'll handle this. Her father was Governor Richard Hartley. Here's the part that gets me. She genuinely seemed to believe that was a reasonable solution. Not an apology, not a question about whether the child was okay, not even a quiet moment of sitting with what she had just been told. Just a suggestion to route the inconvenience through the right administrative channel and have it disappear before dinner. I don't say that to pile on a teenager. I say it because it tells you something important about what privilege left completely unchecked across an entire childhood does to a person's internal compass over time. It doesn't make them cruel, it makes them genuinely unable to perceive the gap between their experience of the world and everyone else's. That gap, in Madison's case, had been growing for years without anyone ever pointing at it directly and saying, "Look at that. Look at how wide that has gotten." Reynolds did not call the governor's office. He filed his report in full, every detail, the speed, the stop sign, the child in the crosswalk, the shaking hands. He wrote it the way an officer writes when he's decided something matters more than the path of least resistance. When he's decided that the easier road isn't the one he's willing to take this time. He also noted at the bottom of his report that he had gone home that evening and held his own daughter for a long time before she went to sleep, and that he hadn't told her why. By the time the court date arrived, the gallery was fuller than usual. Parents from Oakmont Elementary were there. Local reporters had positioned themselves near the back. Word had moved through the community the way word moves when people sense that something is being decided that affects them directly. There were no signs, no chanting, no organised demonstration, just parents who had heard about a child frozen in a crosswalk. who had thought about their own children walking to school that same afternoon, who had maybe driven that same route themselves and knew exactly how fast 55 miles per hour would feel on that particular street. They showed up because they needed to see what happened next. The atmosphere in the courtroom that morning had a specific texture to it. Not hostile exactly, more like attentive, in a way that went beyond casual. People were watching more carefully than they usually did. The parents in the gallery weren't there to see punishment handed down. They were there because the outcome of this case was going to tell them something about how the place they lived actually worked, about whether the rules that applied to their children applied equally to everyone, or whether certain names and certain connections still functioned as a kind of invisible exception. When Madison walked in with her attorney, a polished man in his 50s, carrying the kind of briefcase that signals serious hourly rates, the room grew quiet in that particular way that means everyone has already formed an opinion and is now waiting to see whether the proceedings will confirm it or complicate it. Her attorney was prepared. He had shaped his argument carefully, the way skilled attorneys do when the legal facts are unfavourable, but the technical standard still offers room to work. No actual collision, no injury, no property damage. The appropriate resolution he suggested would be a reduced charge, traffic school, and a reasonable fine. Clean, efficient, designed to close the case without anyone having to sit with too much discomfort for too long. It was a professionally constructed argument. The problem wasn't the logic of it. The problem was that the logic was being applied to a situation where logic alone was insufficient. What would you have done if you were sitting in that gallery? Drop a comment below. I genuinely want to know whether you think the attorney's framing was legally reasonable or whether something about the way he presented it felt wrong to you. Judge Caprio nodded at the argument, the way judges nod when they're not agreeing but not arguing either. They're deciding. He turned to Madison and asked her a question that sounded simple. When she saw the stop sign at that intersection, what was she thinking? Madison hesitated. She said she didn't really remember the specific stop sign. She drove that route frequently. Caprio let that answer sit for a moment. He didn't react visibly. He just let the silence hold the words for a second before moving forward. Then he asked for the security footage to be displayed. The courtroom watched silently as the footage showed the intersection from an elevated angle, the timestamp in the corner. Madison's car entering the frame moving far too fast for the street it was on. The stop sign passed without any visible deceleration, and then David Chen in a crosswalk, 3 careful steps in, and then frozen. The car swerving at the last second. The footage held on that frame. A child suspended in the moment of his fear, backpack still swaying gently from the rush of displaced air. The judge looked at Madison. "Do you see that child?" She glanced at the image. "Yes, Your Honor." "His name is David Chen," Caprio said quietly. "He is 7 years old. He had nightmares for a week. He asks his mother every morning if the fast car lady will be at the crosswalk. He is afraid to walk to school." Madison's attorney stepped in again, measured as ever. His client felt terrible about frightening the child, but the legal facts remained unchanged. No contact, no injury. Emotional appeals, while understandable, did not alter the legal record. Judge Caprio looked at him with the patience of someone who had heard that argument shaped in many different ways over many years and had never once found it persuasive in cases like this one. He said simply that in his courtroom, legal facts and human impact were not separate things. They were the same thing. The law existed because of human impact. Pretending they could be evaluated independently was a way of making the law smaller than it was designed to be. Then he turned back to Madison. He had been reviewing her driving history, he said. This was her 5th traffic violation in 2 years. She started to respond. He raised a hand, not unkindly, and continued. What concerned him wasn't the violations themselves. Young people made mistakes, pushed limits. That was part of growing up and figuring out where the lines were. What concerned him was that every single previous violation had quietly disappeared before she was required to face any real consequence. And every time that happened, he told her, something was taken from her. Each time a problem was erased, she lost the chance to understand what her choices actually cost other people. There's something in that observation that I find myself returning to beyond this specific case. We talk about shielding people from consequences as if it's always an act of care. Sometimes it genuinely is, A parent helping a child navigate a system that's too complex for them. A community supporting someone through a setback they couldn't have anticipated. But there's another version of it that works quietly against the person being protected, that removes every opportunity for them to develop the internal equipment they'll eventually need. Madison hadn't built that equipment because no one had ever required her to. She had been handed outcomes without the process of earning them, handed clean slates without the work of understanding why they needed cleaning. That's not entirely her fault, but it was absolutely her problem now, standing in that courtroom, realizing for perhaps the first time that the equipment she lacked was exactly what this moment required. Madison's composure had been slipping for several minutes by then. The frustration finally surfaced fully. She told him it wasn't fair to bring up cases that had already been resolved. She was prepared to pay whatever the fine was. She just wanted to deal with this and return to her life. There was genuine exasperation in her voice. The exasperation of someone who had come to a place expecting a transaction and was being offered something she hadn't asked for and didn't know what to do with. Judge Caprio let the silence rest for a moment. Then he said, almost gently, willing to pay the fine, as if David Chen's nightmares had a dollar amount attached to them, as if Officer Reynolds' hand stopped shaking the moment her credit card went through. And that's when Madison said it, the sentence that stopped the room. She said her father was the governor. She said the judge couldn't treat her like some common criminal over a speeding ticket. The courtroom went so quiet that people in the back row later said they could hear the ambient hum of the ventilation system. Nobody moved. Nobody coughed. The reporters in the back held their pens completely still. Even Madison's attorney, who had been preparing his next careful interjection, went silent. Judge Caprio removed his glasses, set them on the bench slowly, folded his hands, looked at her with the steady, unhurried attention of someone who had been waiting for exactly this moment. Not because he had wanted it to arrive, but because he had recognized it was coming and had decided in advance what needed to be said when it did. When he spoke, his voice was quiet enough that people leaned forward slightly to hear. He said that his own father had been a barber, that his father had taught him character isn't measured by a title, it's revealed by choices. That Madison had chosen to endanger children that afternoon. That choice said more about who she was than any family name ever would. That in his courtroom, she was not the governor's daughter. She was someone who had forgotten that privilege carried responsibility with it. That the two things were not separable. That you could not hold one and discard the other and call yourself entitled to either. 15 seconds. That was all it took. Madison's face moved through several things in rapid succession. The anger came first, reflexive and familiar. The kind that had probably worked in other rooms and with other authority figures throughout her life. Then confusion, genuine and visible, because the room wasn't rearranging itself around her the way rooms usually did. The framework she'd operated inside her entire life, the one where her father's position created a kind of ambient protection, a field that softened edges and redirected consequences, wasn't functioning here. And she didn't have another framework to switch to. Then something that looked, for a real moment, like the beginning of actual shame. Not performed shame, not the calculated display of remorse that attorneys sometimes coach defendants to present. The real kind. The kind that arrives when someone finally sees themselves from the outside and doesn't recognize what they're looking at. Her attorney put a hand on her arm. It was the right instinct, and he knew it. Caprio let the silence hold for a few seconds longer. Then he told her he didn't believe she was a bad person. He believed she was someone who had never been allowed to learn what responsibility actually meant. Because the people who cared about her had always moved to protect her before responsibility could teach her anything. Every time someone erased a consequence, they didn't protect her. They prevented her from becoming who she needed to become. And now, at 19 years old, she was standing in a courtroom having to confront a 7-year-old's nightmares because all those earlier, smaller confrontations had been quietly cancelled on her behalf. He asked Mrs. Chen to come forward. A woman in her late 30s rose from the gallery and moved to the front of the courtroom with the quiet composure of someone who had spent days preparing to be steady in this room, because she understood that falling apart wouldn't serve her son. She had rehearsed what she wanted to say, not because it was strategic, but because she knew that when she saw the person who had nearly taken David from her, every prepared sentence might leave her at once, and she needed something to hold on to. She stood at the front and looked at Madison directly, not with cruelty, not with performed accusation, but with the kind of honest eye contact that carries real weight behind it. The look of someone who has something important to say and has decided to say it clearly. She told Madison about David, how he loved dinosaurs and could recite the name of every species in his picture books from memory, correcting adults who got them wrong with gentle seriousness. How he loved building things out of whatever he could find and then explaining in detail exactly how they worked and why. How he asked questions constantly about everything. Why bridges stayed up, how clouds formed, whether animals dreamed. How he had started second grade that fall, genuinely excited about it, carrying his oversized backpack like a badge of honor, telling his mother every morning what he was looking forward to learning that day. She told Madison that after the crosswalk he stopped sleeping through the night, that he woke up crying from dreams she couldn't always reach him inside of, calling out in a way that told her whatever was happening in his sleep was immediate and real to him. That he asked her every morning without fail before they left the house whether the fast car lady would be at the crosswalk. That she had started taking a longer route to school just to avoid that intersection because the direct route made him grip the door handle of the car until his knuckles were pale. That he held her hand crossing streets now with a grip so tight it left marks on her fingers. That he flinched at cars that moved too quickly through their neighbourhood. That a single Tuesday afternoon had quietly reorganised the way her 7-year-old son understood whether the world was a safe place, and that she didn't know yet how long it would take to reorganise it back. She wasn't angry when she said it. She wasn't performing grief. She was just telling the truth about what her son's life looked like now, in the specific, concrete terms that made it impossible to hold at a comfortable distance. Madison's composure was completely gone by the time Mrs. Chen finished. The tears came without any performance behind them. There was nothing left to manage. Whatever wall she had maintained through the earlier parts of the proceeding had simply ceased to exist. What struck me about that moment, and I thought about it more than once since, is that Judge Caprio didn't engineer a humiliation. He engineered a confrontation with reality. There is a real and meaningful difference between those two things, and it matters. A humiliation is designed to make someone feel small, to reduce them. What Caprio did was remove the distance that had been insulating Madison from the actual human cost of what had nearly happened. That distance had served her well for 19 years. It had kept things clean and abstract and manageable. When it was finally gone, she had no defense left, and maybe for the first time in her life, she didn't reach for one. She just sat there with what was real and let it be real. That's what a truly skilled judge does in the rare moments when circumstances allow it. Not simply rule, not simply sentence and move to the next case, but identify the specific moment where the person standing before them might actually absorb something that changes the direction they've been traveling. Most judges don't get many of those moments. When they arrive, they require a particular kind of precision, not too soft, not too hard, aimed at transformation rather than punishment. Caprio found one that Tuesday morning, and he used it with care. After Mrs. Chen returned to her seat, the courtroom remained unusually quiet. Not the hell-breath silence of waiting for something to happen, but the settled quiet of people who had just witnessed something and were still deciding what to do with it internally. Madison sat at the defendant's table without speaking. Her attorney had stopped preparing counter-arguments. Even the reporters in the back had set their pens down. Judge Caprio reviewed the case file once more before delivering his ruling. He imposed a significant fine. He ordered mandatory community service hours to be completed at Oakmont Elementary School specifically, not somewhere abstract and removed from the consequences of her actions, not a neutral location where she could complete hours without any connection to what had brought her to this point, but at that school, around those crossing guards, in the vicinity of the families whose lives her choices had touched. touched. Her license was suspended pending completion of a comprehensive driver awareness program. Not the standard traffic school checkbox, but a full course designed to rebuild a driver's relationship with the responsibility of being behind the wheel. And he noted for the record that Officer Reynolds had maintained the integrity of his report under circumstances that would have made it professionally easy and personally convenient to do otherwise. That deserved to be acknowledged out loud, Caprio told the courtroom. So he was acknowledging it. Madison left the building without speaking to reporters. Her attorney made a brief, careful statement outside that said very little. Officer Reynolds was present for the hearing and didn't give any public comment afterward. He didn't appear to need to. He had already said everything he needed to say in the report he filed the day he decided not to make the phone call. If this is the kind of storytelling that matters to you, subscribe to Frederick Explains Court. These stories deserve to be told carefully, and there are more of them worth your time. I think about this case sometimes when I'm covering something else entirely, when I'm reading through a new file and the facts seem straightforward on the surface. I think about it not because it resolved perfectly, or because everyone walked away visibly transformed, or because the story has a clean ending that satisfies neatly. Life doesn't usually work that way, and I try not to tell these stories as if it does. I think about it because of the specific texture of what Mrs. Chen said near the end of her testimony, that her son holds her hand crossing streets with a grip so tight it leaves marks on her fingers. There are consequences that show up in courtrooms, fines logged in official records, license suspensions noted in databases, community service hours verified and signed off. Those are the consequences we can measure and point to. They have paper trails. And then there are consequences that don't appear anywhere in any official record. They show up in a 7-year-old's grip, in the way he checks the street not once, but 3 times before his foot leaves the curb, in the question he asks his mother every morning before school, in the longer route she takes now, just to avoid a specific intersection, in the way a child who once walked through the world with open, curious confidence now moves through it with a fear he didn't have before and didn't earn. Those consequences don't resolve at a hearing. They don't have a fine schedule. They just become part of how David Chen experiences the world for however long it takes for them to fade, if they fade completely at all. Reynolds didn't make the phone call. Caprio didn't soften the moment. A mother stood in a courtroom and described her son's hand leaving marks on hers. And something in that room shifted in a way that paperwork alone never produces, in a way that no fine schedule or legal standard can fully account for. That's the part of the story that doesn't leave you.